So what concept we had started? General Clauses Act 1897. This is the act of all the acts, laws of all the law. This is a central law. So in that particular act, we are discussed about the definitions and general topics were discussed. And now we are going to be discussed about the miscellaneous topics. So what are the different definitions we have studied and general topics we have studied? And also we will discuss in ICA textbook. What are the matters in the ICA textbook? We will discuss about that. Miscellaneous topics. So simple. So I can ask some questions. You can answer it. So listen. So listen. Wait a minute. So listen. So in case of General Clauses Act, I can ask some small questions, sir. You can answer it. So you know about the Securities Exchange Board of India. You know about the Reserve Bank of India. You know about the Competition Commission of India. Like that, these are the authorities. You know about these all authorities. Securities Exchange Board of India, Reserve Bank of India, and Competition Commission of India. So these are all our institutions. So here, SEBI consists of chairperson. So RBI consists of governor, and the CCI is also consists of chairperson. Okay, so like that, each and every institution is having this all scenarios. So whenever the chairperson is there, and out of that, one person, so governor is there. So we are talking about the RBI. Why? Because most of the people are familiar about RBI. Then we are go through with RBI. So RBI may then governor is there, then deputy governor is there, deputy governor, and reminding sir, one person nominated by RBI is there, and three persons nominated by central government. Like that, these many people, these categories of people, these many people are the, in case of RBI, there is a one committee is there that is called as Monetary Policy Committee. MPC is there. In that particular MPC, these are all our categories. These are the people. All people together, they can form a Monetary Policy Committee. So what is my question here? Who can appoint the governor to RBI? Who can appoint the governor to RBI? Who can appoint the deputy governor to the RBI? Who can appoint, sir? Generally, central government. So central government is having a power as central government has a power, then they can appoint a governor and they can appoint a deputy governor also. Then what this governor and deputy governor, the panel, they can recommend whom, sir? One person. Then central government recommend three more persons. Like that, this is the combination, sir. So why we are discussing here now? This is simple example. What is that? Sir, here, whenever central government is having a power to appoint governor, power to appoint governor or not? Yes. At the same scenario, central government is having a power to remove a governor also. Remove governor, yes. So here, the authority who is having a power to appoint, the same authority is having a power to remove a person also. This is one basic condition. And so here, whatever the rules and regulations are applicable to the governor, same rules and regulations are applicable to deputy governor, same rules and regulations are applicable to the persons who are nominated by RBI, The same rules and regulations are applicable to the persons who are appointed by the central government. So whatever the rules and regulations are applicable to the highest authoritative persons, for the subordinates also, they used to follow the same rules and regulations. That is second point. Yes, sir. What are the rules and regulations appointed to a particular person? So authority, the highest authority, what type of rules they has to follow? The same powers and regulations are followed by the subordinates also. Okay, sir. That is the second rule. So in this RBI is an institution, SEBI is an institution, the CCI is an institution. These are all our functionaries. These are all our bodies, functionaries and institutions. So these persons may come and may go. Sir, governor may come and govern. Olden days, Saguram Rajan is a governor. Today, Siktikanta Das is a governor. Olden Ujjit Patel is a governor. Today, Siktikanta Das is a governor. So the members may come and members may go. These functionaries are always a continuous process. These are all institutions. So that is only a position enjoyed by the people. The persons may come and the persons may go, but these institutions are continuous existence. There is perpetual succession. Yes, that is the third point. Clear? Then now we are discussed about, we are go through with that our material. What are there in our material? Power and functionaries. Power and functionaries. Section 14 to 19. So listen. So power conferred to exercisable from time to time, whereby a central act or regulation made after commencement of this act, any power is conferred, then unless a different intention is appears, the power may be exercised from time to time as occasion requires. SEBI, they can exercise the powers. As an RBI they can exercise the powers. CCI can exercise the powers, or IRDAI, they can exercise the powers, or and also, sir, we know about NABARD. NABARD, they can exercise the powers. These are all our functionaries that time to time they can exercise their powers. Okay, so listen. So listen. Next, sir. Power to appoint to include power to appoint ex officio also, whereby any legislation or regulation, a power to appoint any person to fill any office or execute any function is conferred. Now, unless it is otherwise expressly provided, any such appointment may be made either by name or by virtue of office. Okay, so power to appoint is include means who are be the persons. Central government has a power to appoint ex officio member. Ex officio is nothing but highest authority, governor of a RBI. Okay, so central government has a power to appoint chairperson of SEBI. So like that, a power to appoint, it means the power to appoint highest authority also. So whereby any legislation or regulation, power to appoint any person to fill any vacancy, unless otherwise any intention is appears. Ex officio, who is ex officio is a Latin word which means the virtue of one's position or office provision under the section states that where there is a power to appoint, the appointment may be made by appointing ex officio as well. Power to appoint means appointment in the sense power to appoint ex officio also. So like the simple example, sir, we are giving a power to the MLAs. Then what MLAs, they can elect a chief minister, and hence we are giving a power to appoint to MLA. They can appoint highest person also, ex officio also, and they can give appointing MPs. Then these MPs can appoint president of India. So power to appoint means power to appoint ex officio. Ex officio is a Latin word which means by virtue of one's position or office. There is a power to appoint the ex officio member. Next one, sir. Power to appoint to include power to suspend and dismiss also. Normal concept, sir. The authority having a power to appoint one person, the same authority is having a power to remove that person, power to suspend that person, power to dismiss that person also. The authority having for the time being in power to make an appointment shall also have a power to suspend or dismiss any other person appointed. So it's a best example. Choices and other 40 rule 1A of CPC Criminal Procedure Code 1908, which authorizes a court to appoint receiver has been construed, embrace a power to removing receiver also. So court means whenever you are becoming insolvent, what happens, sir? They can appoint an official assignee or not. Official assignee is nothing but receiver, official liquidator. Who can appoint, sir? Court can appoint. The court is having a power to appoint a receiver. The same court is having power to remove the receiver also. Processor, the construction of the empowers a chief justice to make appointment officers as servants of high court has been interrupted to include power to suspend or dismiss also. CJI, sir. CJI, Chief Justice of India, Bob Day now. The Chief Justice of India, then he can appoint, so olden days was before that, now the Bob Day, various Ranjan Gogoi. So Chief Justice is having a power to appoint over sir, High Court Justice officers which are related to the High Court. Who is having a power? CJI. Means power to appoint includes power to remove such person also. Okay, sir. Next, sir. So in another situation, best example. Everyone is clear? Power to appoint ex officios. Power to appoint includes power to dismiss also. Okay, so power to dismiss also. So, next, sir. Suppose, best example. Yeah. Political scenario is very useful. Whenever, what happens, sir? Prime Minister. Who is our Prime Minister? Narendra Modi. So before that, so what happened? In that Narendra Modi cabinet, so many ministers are there. Out of that, Arun Jaitley is one of the minister. Now he has died. No, Arun Jaitley, previous finance minister. So whenever the Arun Jaitley is appointed as a finance minister of India during the first tenure of India government, so what happened after some days? Arun Jaitley died. Whenever Arun Jaitley died, whatever the ministry works of Arun Jaitley, that can be transferred to whom, sir? Piyush Goyal. At that point of situation, now he's a railway minister. At that point of situation, the moment when Arun Jaitley is died, whatever the functions done by the Arun Jaitley, whatever the works of Arun Jaitley, what is the obligations and duties, sir, everything can be transferred to whom, sir? Another person, another minister. Sir, here, whenever he is appointed on behalf of this particular person, whatever the powers to relate to this person is transferred to this person, whatever the rights related to the Arun Jaitley, same rights to the Piyush Goyal or not. Whatever the powers related to the Arun Jaitley, the same powers related to the Piyush Goyal or not. Whenever one person is replaced with another person in that particular position, whatever the rights, privileges enjoyed by that particular person, the same rights and privileges are transferred to the person who so appointed. Yes, obviously, sir. Obviously or not? Yes, sir. Here one person is appointed. Instead of that particular simple example, say you know about auditing, you know about auditing. So an auditor is appointed as an individual is appointed as an auditor. Individual is appointed, generally his tenure is 5 years. As a statutory auditor is appointed individual 5 years. Suppose Mr. Ram, Mr. Chartered Accountant, Mr. Ram is a Chartered Accountant. He is appointed as a statutory auditor of X company for individual 5 years. So after completion of 2 years, he don't want to continue. He wanted to resign or he died. At that point of situation, in his place, another person is appointed or not. Whenever in his place other person is appointed, whatever the privileges, whatever the rights related to the Ram, all rights, privileges, advantages are transferred to whom, sir? The person who so appointed now. Same or not? So in others position you are appointed, whatever the rules and regulations, what are the matters related to the other, the same are transferred to you, sir. Okay. So that's. Students, the next one is substitution of functionaries. In any central act or regulation made after commencement of this act, it shall be sufficient for the purpose of indicating the application of law to every person or number of persons for time being, executing the functions of an office. To mention the official title of the officer at present, executing the functions, or that the officer by whom functions are commonly executed, these sections are also all central acts made after 3rd day of January 1868, 14th day of 1887. Substitution of functionaries. So what is that substitution of functionaries means? Sir, before, sir, company law tribunal is there. Now, company law tribunal is substituted by NCLT or not? Yes. Before, sir, before, what happened, sir? Capital. Okay, so issue capital related issue CCI is there, not competition. Capital related issue. Now it is related, is substituted by SEBI or not? Yes. So like that, whenever there is substitution of functionaries, if any central act is made after commencement of this act, it shall sufficient for the purpose of indicating application of the law to every person or number of persons for time being executing the functions of an office, to mention official title of the officer at present executing the functions. So if any central act regulation made after the commencement, it shall be sufficient for the purpose of indicating the relation of law that successors are of any functionaries of corporations having a perpetual succession, whereas some persons are come and persons are died, but the successors they come and go. The institution is always function is always having perpetual succession. Resignation, official chiefs and subordinates. So whatever the rules and regulations, what are to the official chiefs, the same thing shall be applied to subordinates also. So it's a law relating to the chief suspension of the office shall apply to the deputies or subordinates also. Whatever the laws are applicable to the chief, the same thing is applicable to deputies and subordinates. Lawfully performing the duties of that office in that place their superior. To prescribe the duty of the superior. So in case under the Prevention Detention Act, where there is a change in advisory board after service of detention order, new advisory board can be considered case pending before the earlier board. Clear, sir? These are the another matters, sir. These are the situations. Simple. What is that? Power and functionaries. Power confer. These are time to time. Power to appoint ex officio. Power to appoint includes power to suspend and dismiss also. Substitution of functionaries and successors. Clear? Whatever the official chiefs and subordinates, whatever the rules and regulations are applicable to the official chief, same is applicable to subordinates also. Clear? This is thing also where states that power to include means power to add, amend, vary, rescind, notification orders, rules and bylaws also. Making rules and bylaws of issuing orders between the passing and commencement of the act. Last class we discussed. So act is passed, but they came into force on one day. Meanwhile, any rules and regulations or any additions are there. These are applicable also whenever the act is came into force. Same thing is we had studied. Clear? Miscellaneous recovery of fines we had studied. Two or more enactments, punishment we had studied. Meaning of service by post we had studied. Citation, reference. Okay, sir. Ordinance. What is ordinance? We are also studying. Acting audience difference we are studying no? Now, sir. Now I can ask some one example, very interesting. So everyone know about Companies Act 2013. So in the Companies Act 2013, or do you know about Indian Contract Act? Everyone know about Indian Contract Act. So this Indian Contract Act consists of 266 sections. Yes. So these 266 sections are segregated into four parts. Yes, sir, four parts. Section 1 to 76, 1 to 75, 76 to 123, section 124 to 238, section 239 to 266. This is a segregation of all 266 sections in India, in Indian Contract Act. 1 to 75 related to the general principles. 76 to 123, which is related to the sale provision, sale of goods related provisions. 124 to 238 related to the special contracts, indemnity, guarantee, bailment, and pledge, contract of agency. So 239 to 266, which is related to what's a partnership. So like that, this is the four segregation of four different types of segregations of Indian Contract Act. But what happened in year of 1930, 1930 में section of 76 to 123 cases, section 76 to 123 is repealed from the Indian Contract Act and framed the separate act. The name of the act is called as Sale of Goods Act 1930. So whenever you can repeal, when the repeals are 1930, they are repealed. So before 1930, the Sale of Goods Act provisions are also in forming part of Indian Contract Act. Later on, that is separated and frame the separate act. So after separation, then you can follow the separated act. So up to separation, we should follow the old provisions only or not? Yes. Once you can separated the act, it will not affect any previous. So previously activities are done, those are affected, no. Previously punishments are imposed, those are affected, no. Previously, okay, some benefits are received, those are affected. Previously, some investigations or inquiries are going on, those are affected. No, sir. Once the act is repealed, after repealed, up to that, if anything is happened, anything is done, whatever maybe that, anything is going on, that is as it is, those are applicable, those are not affected. Obviously, sir. You can prepare the one act. Out of that, what happened? Best example, 1956 Companies Act is there. The moment when 1956 Companies Act is repealed, they can frame the Companies Act 2013. Now, which act is applicable? Companies Act 2013 is applicable. 1956 is applicable or not? It is not applicable. So, but up to 9 means the Companies Act 2013, whatever the transactions are happened, whatever the inquiries are happened, whatever the punishments are made, everything as per 1956 Act only. Now today 1956 Act is also not there. Even though whatever the activities are done previous to the Companies Act 2013, those are not affected. Repeal is not affected. Those are not affected on previous penalties, previous punishments, previous benefits, previous whatever it may be. Repeal of an act, either partial or complete, sir. Whatever repeal cannot be affected, whatever the done in the past. So this is the best scenario. Clear, sir? Everyone is clear? Tell me, sir, everyone is clear or not? No. Listen, sir. Sir, all laws affect the substantive vested rights generally operate prospectively, and there is a presumption against their retrospectively till there are express words are giving. Generally, today Act is came into force. 2013 Act came into force and concept. Generally, Act is applicable after 2013. They say at the time of making Act, they clearly mentioned, even though before also 2013 Act is applicable, then as per mentioned in the written agreement, then that can be applicable. Others. All laws which are effective substantive vested rights generally operated prospectively, and there is a presumption against their retrospectively till there are express words giving retrospect effect, or where the language used necessarily implies that such a retrospective operation is intended. And the question whether a statutory provision has a retrospect effect or not depends upon primarily on the language which is couched. So it's the effect of repeal. If you repeal that, where any central legislation act or any regulation made after the commencement of this act repeals any act, repeals any act made or yet to be made, they can repeal, and they can be suppose 1930 days are repealed and frame the separate act. So repealed, either made a separate act, repealed, they are yet to be made the separate act. It repeal shall not, whenever you can repeal, shall not revive anything is not enforced. Revive effect of previous, or they cannot not affect the previous operations, not affect any right, privilege, obligation, liability acquired, does not affect any penalty, does not affect any inquiry, litigation, and remedy. Yes, obviously, yes. We can repeal the provision. Whenever you can repeal the provision, the repeal is not affect revival of anything, not enforced, not affect the previous operations, not affect any right, not affect any penalty, not affect any inquiry, investigation, remedy. So listen, this is important. So repeal of a provision is in distinction from deletion of a provision. Repeal ordinarily brings about complete obliteration of a provision as if never existed, therefore affected all incoherent rights and all causes of action related to the repeal provision, while deletion ordinarily take effect from the day-to-day legislation effect said deletion, never to affect total affecting on wiping out. So repeal means what happens, sir? The entire provision can repeal. Delete means the word, a particular word can be deleted. So it's a repeal of a provision in the distinction from deletion of a provision. Repeal ordinarily brings about complete omission, totally cancel of a provision, but never existed. That is, if it is never existed, thereby affecting all incoherent rights and all causes of action related to the repeal provision. While deletion ordinarily take place, effect from date to legislation affecting the said deletion, never to affect total effect on wiping out of the provision. So if they cannot delete the entire, sir, delete means on a particular part, a particular line, a particular word only you can delete. Repeal means entire provision can be revived, repealed. Okay, sir. So repeal of act making textual amendments or act regulations. Revival of repeal enactments. After repeal, if further any requirement is there that you wanted to revive, then you can revive, no problem. Clear? So it's the best example. In the section 115 JB of Income Tax Act 1961, for a calculation of book profit, the companies and 1950s are required to be referred with the Advent Companies Act 2013. Simple examples. So whenever, in case of we are studying about Partnership Act 1932, in that particular situation, number of members, minimum two members, maximum 50 members. So the number of members concept we are not discussed under Partnership Act. The number of members we are considered under Companies Act. We are considered under Companies Act. Okay, sir. As per Companies Act, sir, whenever a company before Companies Act 2013, we are mentioning Companies Act 1956. No, whenever Companies Act 1950 is amended, Companies Act 2013, wherever the reference is given for Companies Act 1956, every reference will be changed with what, sir? Companies Act 2013. Okay, na? Simple examples, sir. Whenever you can go through with the act, you are giving reference to the acts or not. Okay, sir. Reference act is amended, then that reference of word also amended. Others recommend. Sure, sir. Sir, 15th Income Tax Act 1961, where calculation of book profit as per Companies Act 1956 they are mentioned. But now Companies Act 2013 changes no. Then in this Companies Act 1956 place, we can replace it with what? Companies Act 2013. Clear, sir? Commencement and termination of time also we are studying. Okay. Now, this is a concept related to the entire General Clauses Act. What are the questions are there at the end? So it's the first question. Question number one. What is financial year? According to the General Clauses Act, financial year starts with the 1st April and ends with 31st of March of the next year. According to Section 3, Clause 21, General Clause that financial year shall means year commencing from first day of April. The term year has been defined as Section 366 of year. According to the British Calendar, General Clause Act means calendar year which states from January to December. So what is immovable property? 326 we have studied. Immovable property, land, benefits arising out of land, things attached to the land, permanently fascinated, anything attached to that. For example, trees are immovable property because trees are benefit arising out of land and attached to that. However, the timber is not immovable property. When trees are felled and are at set time, then it becomes a movable property. This is also where states as per the provisions of the Companies Act 2013, the whole key manager person shall not hold the office more than one company, except the subsidiary company. Except subsidiary company means subsidiary companies also. Singular includes plural also. So this is also we have studied. The notice when required when the statutory rules are sent by registered post acknowledgement due. Acknowledgement due means is evidence if you are received or not. But is deemed the defected pre properly addressing, properly posted, and properly paying. Then only that is nothing but service by post. But timber is not a movable property, it's a movable property. So dividend of shareholder AGM held on 20th. Dates during which Komal required to pay dividend within 30 days. Days during which Komal required to transfer the unpaid unclaimed dividend in 7 days. Repeal ordinarily brings out complete obliteration, thereby affecting inherent rights and all classes of action related to the repealed provision, while deletion ordinarily takes effect from the date of legislation affecting said deletion. Repeal means entire provision is obliteration. Deletion means a particular word can be deleted. This is also calculated. Okay, so these are the concepts. So this is the previous 2020 examination question. There are two ways to reach city A from city B. The distance measured by two cities by roadways in 100 kilometers and water 80 kilometers. How is the distance measured? For the purpose of any central act, provision of General Clauses Act 1897. So how, sir? Whenever you wanted to measurement of distance from one place to another place in the form of straight line basis on a horizontal basis, horizontal plane you are mentioning, straight line basis you are mentioning. Yes. Measurement of distance I will show it. No, sir, this is section 11. Section 11, sir. Measurement of distance. In the measurement of any distance for the purpose of any central act, regulation made after the commencement of this act, the distance shall, unless different intention appears, be measured in a straight line or horizontal plane. That can be mentioned. అది మెన్షన్ చేయాలి సార్. Clear? 2 plus 2 marks కోసం సార్. Simple. No? Next. So define the following terms with reference to the general clause set affidavit and good faith. These are also we are studied. What is affidavit and what is good faith? అది కూడా మనం డిస్కస్ చేసాం. How many marks, sir? 4 marks. 4 to 6 marks in GCA. 6 marks, sir, GCA. Very easy, simple. So another, sir. 2021 January. January 2021. Recent, sir. Income Tax Act 1961. So answer two questions, 4 marks. PK and VK had long dispute regarding the ownership of a land for which the legal suit was pending in the court. The court fixed the date of hearing 29/4/2018, which was announced to be holiday subsequently by the government. Which what will be the computation of time regarding to the case of central government and the General Clauses Act? Same thing we have studied. Last day is working holiday, then next working day whenever the office is open. That is the situation. Income Tax 1961 provides that the gratuity paid by a government to the employees are fully exempted from the tax. We are required to explain the scope of the term government and clarify whether the exemption from the gratuity income will be available to the state government employees. Give the answer according to the provisions of General Clause Act 1897. Fully exempt from the tax. You are required to explain scope of the term government and clarify whether the exemption from gratuity income will be available in the state government employees. Give your answer in any accordance with the provisions of state government and central government definitions. You have to write. To the act done negligently shall be deemed to be done in good faith. Comment with the help of provisions. Yes, act done negligent with negligence or without negligence, that is deemed to be treated as a good faith. Good faith definition we have studied. Now, this is the two previous examination papers, sir. Very simple.